Hello, everyone. Welcome. Am I still muted? No. Okay, great. It's so wonderful to see you all here. This is amazing. My name is Karima Dillard, and I am the Director of Policy for the Georgia Coalition Against Domestic Violence, also known as GCADV. We are the federally recognized statewide coalition, and our members consist of community-based and shelter domestic violence programs all across the state. In 2015, we started a program called the Justice for Incarcerated Survivors program when we realized that between 74 and 95% of women who are incarcerated are also survivors of domestic or sexual violence. And we wanted to do something to mitigate that harm. So we developed a parole project, and the parole project connects survivors of domestic violence, sexual assault with pro bono attorneys, and the attorneys would help them get paroled. And we did that for years. That program was largely unfunded. We didn't have dedicated staff for it. And then we found Ellie, and we've known for a long time that the laws in Georgia have not caught up with our developed and expanded understanding of domestic violence, and we needed to do something about our statute, but we didn't have the capacity to do it. And then Ellie came, and we have just been waiting for her. So I just thank you all so much for being here. I'm going to turn it over to Ellie to introduce herself and to talk about what we are here to talk about today. Thank you all so much for being here.
Thanks so much, Karima, for that super kind introduction and kicking us off. So Karima mentioned, my name is Ellie Williams. I'm the legal director of the Justice for Incarcerated Survivors program at the Georgia Coalition Against Domestic Violence. A lot of you have heard me joke, it's the longest job title in the world. So we like to use our acronyms, the JAFIS program and GCADV, which you'll probably hear throughout this presentation. So today we're going to talk about as Karima has mentioned, we noted through our work, which we'll talk a little bit more about, the need for legislative change surrounding how survivors of domestic violence interface the criminal legal system. And so we're going to talk a little bit about this new effort we have undertaken in collaboration with a lot of amazing partners who you'll hear from today, including the Georgia Justice Project, Igniting Hope Georgia, the Georgia Women's Policy Institute, a program of the YWCA of Greater Atlanta. We're working with Women on the Rise, a lot of different amazing folks. And we've been having conversations with a lot of you on this webinar and some other folks, and we're excited to have you here if you're new to us about kind of what the needs are in our community and what seem like the best options for solving them. So we'll tell you a little bit about this effort we've undertaken, about the legislation we're hoping to propose in this legislative session, a little bit of the details as to the type of reform we're seeking to push. And we also have some fabulous speakers here with us who will tell you a little bit about survivor justice work and the criminalization of survival more broadly around the United States. And then you'll hear from some organizations and some directly impacted folks in our own community who can talk to you a little bit more about the criminalization of survivor in Georgia. And at the end, hopefully we've persuaded you to join us in some way, shape, or form on this effort, and we'll talk to you a little bit about next steps and ways to get involved. So we're not going to talk about the Survivor Justice Initiative and the legislation, and I believe Wade Askew from the Georgia Justice Project and Rachel Holmes from the Georgia Justice Project might help me out a little bit here and on the next part, so y'all feel free to jump in at any point. So the Survivor Justice Initiative, as Karima pointed out, really came as a culmination of the work that we've been doing over the past almost decade in the JAFIS program, but that a lot of people around the state have been doing and the country really for years and years and years. This issue isn't new, but it's more recently getting directed funding, attention, programmatic support. And we were all noticing that we're able to do really great things in the courtroom and through advocating for parole, but that we're constantly facing this uphill battle of the law really not working for survivors and not being effectively constructed to account for what's really happening in these situations where survivors are put in a situation where they have to, sometimes we describe it as choose between several really difficult, terrible choices of staying in a situation that risks them being continually abused and risk their safety or their children's safety, or risk a situation where they undertake some action or inaction that might lead to them facing criminal charges. That might be protecting themselves against their abusive partner. It might be doing something that their abusive partner instructed them to do. Could be a number of things, but we know that survivors are going to prison for doing what they had to do to survive. The need for this change is great because we know that a lot of people incarcerated in Georgia prisons are affected by abuse, largely women. The national statistics show that up to 95% of women incarcerated in the United States report having experienced domestic or sexual violence in their lifetime. Between 1980 and 2016, as you see here, the number of women incarcerated in our country has increased 700%. And there are thousands of women incarcerated in Georgia's prisons. So what we've identified that we need to do is we notice that again, over time, our understanding of domestic violence has evolved. We understand its dynamics better. We understand how and why it happens better. So we look at these situations and we're able to see that there's a lot of context, circumstance, and history that's critical to really understanding what happened, why someone might have committed an act that could lead to or did lead to criminal charges and subsequent prosecution and potential incarceration. But the system as it's constructed now is really looking, and we hear this from survivors a lot too, all they care about is that moment in time, what happened, did I pull the trigger and did he die, or did I drive the car, or did I yada yada. But what we're not doing effectively is looking at why that might have happened, creating infrastructure for folks to explain that, have it be meaningfully considered, and make sure that what's happening as survivors are navigating the criminal legal system is appropriate, including sentences. We know that women generally are sentenced at disproportionately high, not rates, but their sentences are disproportionately long. And we know that folks are facing really long sentences, often life sentences, who are survivors. And Georgia has done a great job of catching the code up to our evolved understanding in other ways, like the passage of the Survivors First Act in 2020, which allows human trafficking survivors to petition for their convictions to be vacated if they can show a tie between abuse and the crime. And that is great because it shows we're headed in the direction of accounting for dynamics of abuse in criminal cases. We know that trafficking and domestic violence actually have a lot of overlap. A lot of folks who are trafficked would identify their partners as, or excuse me, their traffickers as their partners. And it's a question as to which of those things came first. They're often very intertwined. So the dynamics are similar. The legislature seems to have its head around that issue in a lot of ways, and our community does too. So this really would be kind of a continuation of that momentum, but would help people who don't qualify under the Survivors First Act, who might be abused but not trafficked, and would offer trafficking survivors additional relief besides the vacature with some other kind of particular remedies, which we'll talk about in a moment. We passed a predominant aggressor law. We expanded our definition of domestic violence to include dating violence beyond what previously was limited to family violence. We passed the lease release law, the address confidentiality bill, a lot of good things, but our criminal code still has some catching up to do. So now we're going to talk to you a little bit about the proposed legislation itself. So what we're hoping to do is push a bill in this year's legislative session to modernize our criminal code to align with this current understanding that we have. And again, build the system out so that we can really offer survivors opportunities to consider these things and ensure that they really are considered adequately in the criminal process. So what we want to do is look at what are each of, when we thought about this initially, as we started talking with GJP and all of these other great partners, talking with survivors, talking with prosecutors, talking with defense attorneys, advocates, all kinds of people in these conversations we've had. We had a roundtable in December of 2023 three at GCADV. Some of you attended. We had one at Lee Arundel State Prison with directly impacted folks in July of 2024. We have one at Alston and Byrd. A lot of you attended in August of 2024. So all of these and other conversations have informed what we've landed on as thinking this could be a good potential solution to this issue in Georgia, at least getting us closer to the system working effectively for survivors. And what we've noticed is we wanted to think about what are the moments in time that we could potentially intervene and make sure that we are preventing convictions to begin with. And a quick aside to those of you who do domestic violence prevention work, you're a huge part of this work already. And we are super thankful because survivors end up in these situations because of continued abuse. So stopping domestic violence is huge in this movement. But looking at affirmative defenses to survivors in situations of self-defense, are they able to adequately explain why they might have perceived that they were really and truly in danger and needed to act to protect themselves based on their experience with their partner? And our self-defense statute was last reformed in 1993, which we know in the last more than 30 years, we have come to understand domestic violence a lot better than we did at that point in time. And the coercion statute has not been amended in over 50 years, which pushing 60. So we have understood clearly a lot more since 1968. But we want to make sure that we can account for when a survivor is instructed to do something by their abusive partner. Why they might really feel that they need to, even if their abusive partner isn't saying super explicitly and directly, I am threatening X harm unless you in this moment undertake X direct action. That's essentially what the law requires now. And our clients are saying, he didn't have to say that. He just had to tell me to do it. And I knew based on previous experience what would happen to me if I didn't comply. We also want to look at sentence mitigation, which we'll talk a little bit more about in a minute, and victim-centered programs, giving survivors meaningful options for relief that really meet them where they are and meet their needs. And these could look like alternatives to the criminal legal system altogether. So sometimes folks say, if he goes to jail, we won't have any money to keep a roof over our children's heads or feed them. Or I don't want to ruin his life. I just want him to stop abusing me. So there are some potential alternative type programs and solutions that we can offer folks that avoid the criminal legal system if that's what feels best to them. And we know that survivors are the experts in their own lives. They know their abusive partners, their behaviors, how they respond to certain things, their family's needs, and what would work best for them. So again, we want to look at coercion, self-defense, and sentence mitigation. And Rachel or Wade, do y'all want to jump in here on any piece?
I'm happy to kind of let you get started on coercion, Ellie, and
Perfect.
Jump in where call me in where.
Okay, I'll call you in on sentencing. Thank you. So we, again, wanted to look at each particular point in time in the system and make sure that we're preventing convictions up front. And then we know that not everybody is going to succeed under these affirmative defenses, practically speaking. And also we know that the criminalization of survival there's a lot of variety in how these situations look. So it's almost impossible to construct a defense that would account for every single person who for whom domestic violence plays a large role in their conviction. So we wanted to also create a post-conviction solution to make sure we can mitigate what criminal consequences they face if they don't succeed with these affirmative defenses after being arrested. So Wade's going to talk a little bit about that post-conviction solution in a moment. But to tell you in a little bit more detail what we're looking at with self-defense and coercion, we again want to expand how we currently interpret the coercion statute and how it's currently written in Georgia. We know that the threat of harm typically, as I just kind of explained, involves a very explicit and direct threat that was chronologically immediately prior to the whatever act the person undertook that led to their criminalization. And again, survivors are saying that's not how it works. They're saying, he said drive the car, so I drove the car because I knew that if I went against him or didn't comply, I would end up in harm's way, because that's what happens in my day-to-day life. So that really doesn't effectively account for the dynamics of domestic violence. And we also know that coercion is not a defense to homicide. And in Georgia, the felony murder rule, which says that if you participate in the commission of a felony and somebody dies in the course of that felony, whether or not you were the trigger man, so to speak, you're on the hook. So we know that a lot of survivors, I hear stories all the time of, he told me to drive the car, I did. Then I wasn't even a part of the incident where someone died. I didn't know he was going to do that, etc. And they end up on the hook for homicide. So we want to make sure that that is not excluding people who really their survivorship is exactly why they ended up going to prison. So we want to look at that statute. We also want to look at self-defense. We want to expand it. Right now, our self-defense statute is written such that there is kind of the general, what we understand self-defense to be, that we are allowed, it's self-defense, you can succeed if you can show that you were responding proportionally to a threat of imminent harm. So we know that survivors, a lot of times, what the objective person out in the world would understand to be imminent harm looks different for survivors, because they know how their abusive partner might ebb and flow in the course of an abusive incident or over the course of a day. Or it might not be safe for them to act to protect themselves until the incident has subsided a little bit, but they perceive to be, and as research supports, really are accurate in their perception that they're still in danger. So we want to make sure we have a carve out in Georgia law that says that we can essentially account for a survivor's state of mind if they can put forth evidence that they were a victim of family violence or child abuse by the decedent in homicide cases in particular. The way that that statute has been interpreted, it's been very limited to requiring a survivor to put forth clinical expert testimony pertaining to their state of mind, and specifically in the form of commenting on whether or not they suffer from battered person syndrome. In our evolved understanding of domestic violence, we've used that term, battered woman syndrome, battered person syndrome, for years. You've probably heard it. It's actually not scientifically accurate. It's not a diagnosis in the DSM-5. And it also kind of pathologizes experiencing abuse. We don't want to send the message that something's wrong with survivors because they survived abuse. We just want to explain, here's what happens to the brain when they experience trauma. Her response was consistent with someone who's experienced trauma. It was reasonable for her to perceive that she was in danger. And we want to show that there is expert testimony can be super helpful, and we definitely want to keep that as an option. We also want to account for other forms of evidence that can be really persuasive that abuse occurred. And we also want to allow for survivors to succeed on self-defense in cases apart from homicide. We want these relationships to end before anybody dies, whether it's the survivor or the predominant perpetrator of harm. So we want survivors to be able to show why they, why their state of mind, what it was, and why they perceived danger reasonably given their circumstances in assault and battery cases, so that we can stop the trajectory of these relationships before any further harm is done to survivors, to perpetrators of harm, to children, to anybody else. So we're hoping to expand this definition and ensure that we're not making it so limiting to require not only have stringent requirements, but said stringent requirements are not don't comport with modern psychological science, social science understanding of abuse and mental health conditions that come as a result of abuse. So we will now pass it to Wade, who's going to tell you a little bit about what we are proposing pertaining to sentencing and post-conviction solutions.
Thanks, Ellie. So, hi, everyone. My name is Wade Askew. I'm an attorney and I'm the policy director at Georgia Justice Project. And we've been really grateful and excited to partner with GCADV, Igniting Hope, Women on the Rise, and many others on this initiative. And part of what we are looking at, as Ellie mentioned here, is that we know that the coercion and self-defense fixes that we're proposing, unfortunately, won't help everyone who is a survivor, who is touched by the criminal legal system, pulling them into the system as a defendant when they themselves are the survivor. And so what we wanted to do was to say, hopefully, the things that we have in place here will prevent a conviction from taking place, from impacting a survivor in the first place. If for whatever reason someone falls outside of those defenses and other available defenses and ends up with a conviction, at the very least, we want to make sure that at sentencing, the full context of their situation is taken into account. So what does that mean? That means that if the fact that I'm a survivor, if the abuse that I was suffering is what the legislation what we're proposing is would say is a significant contributing factor. If my situation was a factor in the events that led to this conviction, then my sentence should be much less than it would be otherwise. And so very concretely, what we're talking about is taking whatever the maximum sentence is, what prosecutor could be going for, what a judge could sentence, take that maximum and actually reduce it by half. And so that is again, concretely what we are proposing in this bill, with the overall goal to say the full context of the situation should dictate that sentencing should look different. Also, mandatory minimums should be, we should be able to go outside of a mandatory minimum, again, to tailor sentencing that's more appropriate for the situation if a conviction does take place. And then the last bit of this, as Ellie kind of mentioned earlier, is to say, we know that there are people in prison today who, but for if this law existed, wouldn't be there in the first place, or if they did end up in prison, would be there for a much, much lesser amount of time. And so we need a path for folks in that situation to be able to get back into court, to be able to show the court evidence that, but for me being sentenced before this new law existed, I would not be in prison today, or my sentence would be much, much shorter. And then what the solution there would be is to provide the relevant evidence, to be able to give all that context that we've been talking about here, to then reduce that sentence and hopefully come home from prison. And the way that we imagine doing that is that folks who currently are incarcerated would be able to submit a petition to the court that says, my situation fits under this new statute. And so I should have the right to come back into court and be able to show my evidence and plead my case to reduce that sentence. But then secondly, we know, especially when we're talking about old cases, we know folks who have been in serving sentences for a very, very long time who were under this exact situation. We know that providing that evidence is particularly challenging. We know it's challenging really for a large variety of reasons, that providing relevant evidence on this topic is particularly difficult for all sorts of practical reasons. We know that that gets even harder when years and years and years have passed to come up with that concrete evidence to show without a shadow of a doubt there is, this was a significant contributing factor. So we also need prosecutors to be able to have the discretion to be able to say, this old sentence is inappropriate, and I, as the prosecutor, in my discretion, think it's in the interest of justice to revisit this. So give a little bit more leeway, a little bit more room for those situations where a prosecutor has identified something's inappropriate. This person, would have been sentenced differently under this law. And so we need to get back into court in recognition of the fact that there might be evidentiary or other issues years and years later. So that's what we're talking about when we talk about sentence mitigation, and also that kind of post-sentencing relief for the folks who, had they gone through the system when we had a better understanding of the dynamics of intimate partner violence, would have been treated differently if this law does go through. And so we also have been following the lead, and really Ellie has been the leader. We at Georgia Justice Project have learned so much from Ellie and GCADV about not only some of the particular dynamics at play in these cases, which we too have seen firsthand, but also what is going on the national level. And so I'll kick it over to Ellie to kind of tee that up. And then I am very excited to hear from a number of speakers today to share what is going on around the country on this topic.
Thanks so much, Wade. We also, likewise, I have learned so much from working with Wade and all of the wonderful people at the Georgia Justice Project on preparing this bill. And as an aside, I'm sorry, we should have said this up front, and Karima might have, and I was all distracted, but we feel free to put questions in the Q&A section or in the chat. The Q&A is helpful because it's being monitored specifically, but we will at the end, we know some of you will have to go, but we will stick around and offer you the opportunity to come off mute and ask questions out loud too. So now I'm going to introduce our next speaker, Rebecca Epstein, who is with the Center for Gender Justice and Opportunity at Georgetown Law Center in Washington, D.C. And she is going to provide you with some super helpful information. She's an expert and has been in the work for a long time and will provide you some great information about survivor justice work around the country and the criminalization of survival around the country. So I'll turn it over to you, Rebecca.
Thanks very much, Ellie. Let me know if you can't hear me. So I'm really pleased to be here. We only just recently heard about this effort and this webinar, and I'm excited to join. There's way too much to present here. So suffice it to say that we've been involved in this work for many years, starting with a report on the sexual abuse to prison pipeline, as we call it, that we first published in 2015, and we updated it in 2023. And Ellie, I don't know if you have the slides. I just have a couple of slides. One of them shows, there we go, thanks. That's, if anybody wants a copy of this report, please get in touch with me. The infographic on the left shows the many paths for survivors going into the system, which we have found has disproportionately affected women and girls, especially women and girls of color. And after the release of our most recent report, thank you, we also recently launched this initiative called the Justice for Youth Survivors Initiative that we are co-launching with the National Black Women's Justice Institute, which is in New York. And the Justice for Youth Survivors Initiative, or JYSI, is aiming to transform the justice system by promoting trauma-informed and gender-responsive policies and practices that keep survivors who are children safe and out of the legal system. So we're trying to get input from prosecutors, defense attorneys, and judges and victim advocates to hear what tools will be most helpful for us to provide them. We're about to launch a 50-state survey that will show laws in all 50 states that provide some of the pieces that Wade and Ellie were just talking about, whether that's mitigating sentences or providing affirmative defenses to survivors of gender-based violence. Just quickly on that next slide, one of the paths that we're focusing on is false reporting. And that's the criminalization of people who go to the police voluntarily, report sexual assault or abuse. The police do not believe them, and on the basis of discrediting the reporter, which has been shown again to happen disproportionately against women, even more so against adolescent girls, they charge them and arrest them on charges of false reporting. I would urge all of you interested in this topic to watch the movie Victim Suspect by the investigative reporter Ray DeLeon, who uncovered hundreds of cases like this across the country. I just want to put in a quick plug here. The Center on Gender Justice and Opportunity is currently conducting a study of women who were arrested after reporting sexual abuse and assault based on the police not believing them. We're looking for participants, so contact me or go to our website to let us know if anyone is interested in participating. We also focused on the issues more pertinent to this call, and that's my next slide, which is the criminalization of trafficking survivors who are children, and also the criminalization of women and girls who act in self-defense against their abusers, which we just heard about. So rather than taking too much time, I'll just add to what the others have said that we're looking at prostitution charges and getting rid of those through safe harbor laws, which some states have. The majority of states have some of these. Some are more effective, some are less. Also eliminating proxy charges like loitering that get around safe harbor laws that narrow the definition of safe harbor to prostitution charges. And then the issue that was just mentioned about coerced commission of offenses. Again, this is disproportionately about women and girls of color, so we're intersectional in our approach, and I think it's important for any effort to be thinking about this through the lens of racial and gender justice. Also pertinent to this call, on the next slide, we're working on a project on exactly this issue of self-defense for women and girls who have injured or killed those who traffic, abuse, or assault them. And our research has found that girls are commonly funneled into the juvenile justice system for this purpose, often are transferred into adult court inappropriately for acts that are rooted in attempts to escape abuse and survive, women as well. So in order, again, in the interest of time, I will just say for our next slide that the consequences of involvement in the system are clearly obvious. There's the long-term impact of having a criminal record that stays with girls as well as adult women. And there's also this cycle that we want to bring public awareness to. And that next slide, which is my last one, is our infographic that shows how this can be a cycle for girls as well as for women. That after the experience of abuse, if it's not treated as such, when there is reactive behavior to survive, and it leads to entry into the justice system, trauma symptoms are triggered, new incidents of abuse might be experienced while incarcerated. And when that girl or woman, if they're lucky enough to be released and not have life sentences, the coping behaviors and re-entry ultimately leads them deeper into the system with a very high risk of re-involvement in the system. So that's a little bit about us. Please check out our reports if you'd like to learn more about what's happening from a national lens. And I'm hoping very much to partner with many of you on this call to support the legislation that you're trying to get passed as much as we can inform and educate who needs to be in order for there to be progress on this front. Thanks very much, Ellie.
Thanks so very much, Rebecca. We super appreciate it. And yeah, I linked our page in the website that links to the Georgetown report in the chat. We will also share it in our follow-up email. And Rebecca has a lot of great resources and information and would encourage you to check out the work that they're doing. And we are looking forward to continuing to work with Rebecca. Next, I'm going to introduce Colleen McCarty. So part of what we're doing, we have been eyeing what's been happening around the country and seems to be effective as far as how to help domestic violence survivors. And Oklahoma had an enormous victory in 2024 in passing the Oklahoma Survivors Act, which is, she'll tell you more about, I'm sure, but they did some really incredible advocacy work to educate their community on the issue. Bring survivors' voices to the table, which is something super important to us as well, and to ultimately get a really, really amazing sentence mitigation bill passed. So Colleen is now going to come on and share with us about the work that they've done in Oklahoma, their takeaways about the criminalization of survival, to provide you some context for what's going on in other states around the country. So Colleen, you can take it away.
Hi, everybody. Thank you guys so much for having me. Can everybody hear me? I'm just going to keep talking and you let me know if you can't hear me. But I'm really excited to be here. I just learned about this call last night, so I don't have any slides, but I'm happy to kind of take you through what we were able to pass in Oklahoma in 2024 and the pathway to victory there and how implementation is going. I was really impressed by the presentation on what you guys are going to try to do as it relates to self-defense and coercion Our bill is only a sentencing mitigation bill, but it works on the front end of the criminal justice system, so what we call the prospective piece, and it works retroactively for people serving time who can prove their abuse and also that it was a substantial related factor in their crime. So in 2022, my legal director, who was not yet my legal director, and I started a podcast called Panic Button about a case of a woman here in Oklahoma who fought back against her abuser. She was handcuffed at the time and had just been sexually assaulted, and she was able to get his gun away from him and shot him as he advanced on her. In legal terminology, for me, that is just a basic self-defense posture. But he was a wealthy man. This was in 1998, and he had a very powerful family here in Tulsa, and they ended up prosecuting her for first-degree premeditated murder. They had a very torrid history of domestic violence. There was tons of reports to police, pictures, everything you can imagine, very well documented. And still, even though she asserted battered woman syndrome at her trial, she lost that. And when you lose that, that's a perfect defense. So she lost that and was convicted and sentenced to life in prison. Her name is April Wilkins. She is my client right now, and she is still in prison to this day in Maple Bassett in Oklahoma. Her story kind of sparked a fire in Oklahoma around the issue of survivor justice. We have the highest rate of domestic violence in any state as far as the incidence of domestic violence, and we're number 3 for the number of women killed by men. So it's a very pervasive issue here. And then we also have been until recently the number 1 incarcerator in the world and the number 1 incarcerator of women in the world. And so it's really where these two issues of violence against women and women's incarceration tend to converge is on survivor justice. And we had some data that showed that 66% of women in Oklahoma's prisons were victims of some form of domestic violence within a year leading up to their controlling charge. So out of the podcast came a coalition that we named the Oklahoma Survivor Justice Coalition, which it looks like you guys have the seeds of the Georgia Survivor Justice Coalition here. And we got our domestic violence coalition for the state, a bunch of the providers, all of the groups that work on criminal justice reform, the ACLU. So it was basically where criminal justice reform and survivor justice came to meet together and form basically an unstoppable force. And we based our bill off of the bill in New York that passed in 2019. And theirs is called the DVSJA, the Domestic Violence Survivors Justice Act. And I'm seeing your question, sorry. So we are in the process right now. I'll get to implementation in a second, but we have a hearing on April's case on February 7th. It's a discovery hearing. She'll be free. Don't worry, you guys. She's going to be free. I'm getting distracted reading the chat. Sorry. So that was in 2022. And through the process of the fall of 2022, we started gathering stories from other survivors in Oklahoma's prisons. That actually April helped us get the survey out and get into the prison and started hearing from a lot of other women. We got 150 surveys back of people who self-identified as criminalized survivors. And from those, we started culling down the stories that we knew we could use in the public. Now, I know I'm talking to this group and every survivor matters and every survivor should be believed. But unfortunately, where we are with the public narrative, we are not to a place where every single survivor story will be received with the same level of empathy as other people's stories are. There are bad facts. Survivors do not always act in ways that we think make perfect sense to a person who's not in their situation. And we needed, for this effort, we really needed the stories to be those that people could identify with. And so we selected 10 stories that we were ready to go public with. Those are of all nationalities, of all races, of all ages. Most of them are older cases where the person, if the bill passed, would go free. So we have about 5 of those that if the bill passes and applies to their case, they will be able to walk free. So 2023 session, that's what this picture is from that you're looking at. The bill did not pass. It was actually dangled in front of our face the whole session that they were going to add retroactivity back into the bill. We refused to support the bill if it did not have retroactivity because lawmakers will tell you that they really, really will pass retroactivity later. They want to break it out. They want things to happen later. The incarcerated survivors can wait. And We learned from the work in New York that that is just not a promise that's going to happen. And I would encourage this coalition to stick with your guns. Do not leave retroactivity on the table. These women will not have another chance to get out if you do that. The only carrot for the lawmakers is to pass the prospective piece of the bill. They want to look like they're supporting domestic violence survivors, but they really don't want to help anyone that has gone before. And so that is what's going to be very hard to get through, but you have to stick to your guns. And a lot of them really like getting the publicity that comes with this bill, but they don't want to do the hard thing of sticking up for the survivors that have been in prison. And that's where you really have to hold their feet to the fire. So through the process of mourning the bill that didn't pass in 2023, we end up getting the attention of the Oklahoma floor leader, and he came forward and said he wanted to be the House author for our bill in the 2024 session. And then we were able to move the Senate pro tem, who's basically like our president of the Senate. And so we had two very powerful authors in 2024 that helped us move the bill. It actually did get vetoed by our governor, even after there was resounding statewide support from our coalition, and thousands of volunteers came forward to support the bill and call in support. It got vetoed at the behest of our district attorney's council. So our district attorney's council here in Oklahoma is very powerful, and they are very opposed to this bill. It's very unfortunate that they've taken that tactic, and they still maintain an oppositional tactic to our bill even now. We ultimately end up passing another version of the bill in SB 1835 that was signed into law on May 21st of 2024. It went into effect on August 29th of 2024. We filed April's application for resentencing on that day. And since then, we've filed 7 other applications, and we have about 10 more in the process of going. We've, since it's passed, heard from 180 people asking for our services, pro bono legal support to apply for resentencing. And we have 50 of those in the queue for what we call further review. So we're in the process of trying to find the evidence for those cases that can move forward. And our bill is mandatory. I would also tell this group that you've got to make sure that the judges don't have a way to get out of it if they don't believe the person should be free. Our bill is a shall. So they shall be resentenced to a lower sentence if they can meet their evidentiary burden. And we also prescribed lower ranges. So they don't get to just say, oh, you're in for life without parole, I shall reduce it. Well, I shall reduce it to life. Ours actually forces them to reduce to a number, and it also allows it to go all the way down to 0. And so those are the things that really give our bill teeth that I would encourage you guys to try to put into your policy. They're harder to pass, of course, but when you spend this much time and this much effort in getting this many people together, you don't want to pass something that's just watered down. And so that is my advice to you guys. We just got our first release on January 8th. Her name is Lisa Moss. She was serving a life without parole sentence. I represented her in court in Seminole County, and she walked free a woman out into the streets because she had served 34 years in prison for the death of her husband. And we were able to prove that she was a victim of rape and a victim of abuse. And she had already overstayed her welcome in DOC by 4 years under the new range. And so I had the great privilege of my life to walk her out of the courthouse, not have to go back to DOC or anything. And so you guys are about to embark on a very exciting and emotional and fulfilling journey. And I just will be watching from Oklahoma to see everything you're going to accomplish.
Thank you so much, Colleen. We're so amazed by the incredible work you all are doing, and it's been inspiring and great momentum for us. So we're super grateful, and it's great to see the success stories and what can be on the other side of this effort if we all come together and get this across the finish line. So now we're going to zoom in a little more closely to our community and hear from a couple of folks. We're first going to hear from Dr. Bridget Ortega. She has a lot of amazing experience, is currently working with a great group called Igniting Hope Georgia, which she'll share more about with you. And if you work with Dr. Ortega, I always laugh that she is the busiest person who claims to be retired that I think exists. She's retired, but she's always like, I can't do that. I have 3 meetings that day. So she is really committed to the work and has done amazing things and has amazing experience. and knows a lot about the lay of the land in Georgia and our people here. And she is going to share with you a little bit now. So Dr. Ortega.
Thank you, Ellie. And I want to just say thank you to Colleen for encouraging us to stick to our guns for those who are currently incarcerated. Thank you for sticking to your guns and encouraging us to do so. I am Dr. Bridget Ortega. I am an advocate, a retired attorney, and proud board member of Igniting Hope. And we are partners and supporters of the Survivor Justice Initiative. Our primary mission at Igniting Hope is to advocate for the release of those who are serving unfair and unreasonable sentences for defending themselves or others. The operative word in our organizational name is hope. The fact that you're here today, interested in ending domestic abuse and fighting for those who are being punished for defending themselves against that abuse, gives us all hope for a better future. Today, I want to talk to all of you, whether you be an advocate, a policymaker, or a direct service provider, about why it is critical to center survivor voice at the heart of your work. Because engaging their voices is vital to making sure that we get this right, but most importantly, that we do no harm. So today you're going to hear some of those voices. So I encourage you, please do not sign off before you do. I want to ensure you that the Survivor Justice Initiative that you've just heard about has survivor voice at its heart. So why is that important? Survivors are the best ones to speak on the issues that affect them. They have the best insight into what systems work and which do not work in response to domestic abuse. They can speak from their experience of abuse and the support that they received or not, and the response to it. So when we listen and respond to views that are different than our own as professionals, in terms of what we think is best, then we're joining with survivors and we can critically assess and address these challenges together. And we also can ensure that services and policies are designed and commissioned to fully meet all of their needs. So how do we do this? I'm going to give you just a handful of things to consider in the interest of time, and then we will hear from survivors. When working directly with survivors, be clear about their role and agree how they want to be referred to. I'm glad Colleen talked about, being very specific in the cases that they chose to put forward in the public. Everybody doesn't want to be in the public, and there's lots of ways that survivors can serve. But one of the things I want to encourage you to do is and understand is that some people may not identify with commonly used terms such as victim and survivor, because they feel that that does not really adequately describe their knowledge and their strength, the strength that they have developed through their lived experience. So when I refer to survivors in this presentation, all of us who have presented, we use it as a general term to include anyone who's been impacted by domestic abuse, either directly or indirectly. But when I work specifically with those impacted, I always ask, how do they wish to be identified? Because we have to recognize that terminology and labels can empower or they can re-victimize people. A lot of times we will ask for a survivor opinion on our initiatives or our projects after the fact, instead of co-creating with them. And I would encourage you, please do not do that. Sometimes we subconsciously or consciously have an us or versus them attitude. But when we work with survivors, there is no us. There is no them. It's only we. And before involving survivors in your work, it is important to ensure that you have appropriate frameworks for managing safety and support. If you can't provide this, then you need to partner with agencies that you can work with that can do that. Using lived experiences as a tool for change is personal and can have an emotional impact on the person sharing. It is important that there are structures for support before, during, and after an event or a consultation. So recognized survivor voice can be powerful, from driving and influencing government policy raising public awareness, helping other survivors feel safe enough to step forward, sharing experiences with other survivors, or educating people at risk. The bottom line is they have much to offer. So instead of doing for, I am here to encourage you to do with. I have so many other tips in my toolbox, but a very limited amount of time. And I think it's important that you hear from people who are directly impacted. So let me leave you with this. Dear survivor, please tell the story of the mountain you climbed, for your words could become a page in someone else's survival guide. For your hopes, not your hurts, could very well shape our future. So I thank you all for listening, and I'm going to turn it back over to Ellie.
Thank you, Dr. Ortega. That was wonderful and a really good centering for all of us on the importance of survivor voices being at the center of this work. And we're super excited. We're working on a survivor storytelling project. I'd encourage you to visit the Survivor Justice Initiative website that Ann linked in the chat. There are a lot of resources on there about the criminalization of survival, what's going on around the country and in other states, data. But super importantly, we have a page on survivor stories that we have some fabulous folks working on some really great media content, videos, interviews with survivors that we're going to continue to update as we complete them. But that'll be a great resource, and we'll feature them on our social media accounts. But we really want to bring survivor voices to the table as directly as we can. So on that note, we're going to have two incredible folks share with you today who you might have met before. So first, we're going to have Katrina Butler, who is going to share a bit about her story with you. So Katrina, you can hop on.
Hello, as she said, my name is Katrina Butler. I am the founder of So Far So Close, where we help with trauma-informed care with women who flee women and children who flee domestic violence relationships. I am also on the board for the Justice for Incarcerated Survivors. And most importantly, I am a graduate of that program, which leads me to why I am here, with my story. Unfortunately, from a young age, I was involved in numerous toxic and abusive relationships, but the one that led me to my incarceration was being in a relationship with my son's father, my twin son's father. We were in a relationship for about 7 years, and he became very abusive. He also was indicating how he was going to start looking towards my children, my daughters, in inappropriate ways and manners. He ended up sexually violating me one day. And although we went through the proper procedures, doing in the hospital, going through the rape kit and everything, and then the police officer saying that they were going to get a warrant for his arrest. And here I was, I went home to my children thinking like, finally, this is over with. But lo and behold, I came home to a very, very angry person, which was my abuser. He did not get arrested. The police officer called me and told me that when they went to get the warrant, the judge asked him, where was I? And the police officer told him that I had went back to the house. And so the judge said, well, she's obviously not scared. They did go ahead and talk to my son's father and kind of warn him, but that did not help. It just made things a lot worse. So there I was trapped in the house and still in an even more abusive situation. About 6 months later, he did it again at knife point. My daughter heard and called the police, and at that point he was arrested. While being in county jail, I got a call from the DA, and the DA asked me, you really don't want to see him go to jail for 20 years, do you? And in my traumatic mind and with being an abuser, you're always the blame for everything. I didn't want to be the bad person. I thought if I answered yes, that I would be looking as a person that was not a good person. And so I gave her what I thought she wanted me to say, and I said no. Of course, she asked my daughter, and my daughter said yes. But he served 6 months in county jail, received a $500 fine, and was ordered to pay child support. I got a phone call when he was released, asking me to come get him. And at that point, I took myself and my children and we fled. I tried to, afford hotels. I didn't know about resources, didn't know where to go. I was unable to stay with family members, and all that ran out. And when I went to my employer and asked for help and told him what happened, he says, "Well, what did you do?" After I told him I had been raped, he said, "What did you do?" Well, at that point, when I tried again asking to another owner of the business, and again that led to being humiliated and talked down to, and it didn't turn out well. I did not get any help. So I eventually, when things got so bad, I stole money to get a house, so that way we would to end our process of being in unsheltered. I had 6 children at the time. I stole money to get a house and to hide from my abuser. When everything happened, and I ended up getting into another abusive relationship, and I told them, confided in them what was happening because I needed help, what to do. And instead of helping me, they used it to coerce me, them and their family members, to me continue to steal. Eventually I got caught. And during the process of when I got a lawyer, the lawyer said, "I don't have a defense for you." And this is after me telling them, showing them recordings, showing text messages, proving, the abuse. He said, "I don't have a defense for you." When we went to court, and when it came to sentencing, as we were walking in the courtroom, he told me, "Be quiet, don't say anything." That let him do all the talking. So after my children read letters, and he just professed that I was a good person to the judge, and then also my abuser also read a letter saying that had it not been for him, then things would not have gotten that bad, and it was his fault. The judge turned around to me and says, "Katrina, you've done some great things in your life, but you allowed somebody to make you steal." And I was served with 45 years, served 7. First time, no priors, anything. I was ripped from my children right there at the courtroom. I was not given the first offenders. I was not allowed to make sure that they were okay before starting my sentence. I was taken right there. But I was one that all I had was my children. I didn't have monies for a lawyer. And when you look at my case is different. There wasn't someone did not lose their life. And on my charges, it said theft. And so you don't see domestic violence in that charge. But domestic violence was very much a contributing factor to my case. But I thank God for the coalition, and Karima, who's on here, received my case, my application, and again with Crystal Moon, who approved my application, and I was able to come home in a little bit less than 5 years. Unfortunately, with the 45 years attached to my sentence, this is technically a life sentence for me, all due to domestic violence. So my case really, really shows, the importance of this legislation, because it's not always that black and white. It's not always someone losing a life. It's someone like me where it may be a little bit harder to prove the abuse, and but it's very much there. So I thank you for listening to my story.
Thank you so much, Katrina. Katrina's an amazing advocate and doing incredible things to help other people with similar shared experiences and just general in the community. I think Katrina lives her life with helping others and serving others at her center as her center focus more than about anybody else that I've ever gotten the privilege to work with. So thank you, Katrina. And now we're going to have our last speaker before we close out, who is also an amazing person and advocate. Her name is Donna McMillan. And Donna's going to share more about her family story with you. Her daughter, Beth Muse, is a survivor who's currently incarcerated at McRae Women's Facility, the new facility that GDC opened. And I'm going to go ahead and click over so I can tell you that this amazing piece of art Beth created, which has a lot of great material that reflects her experience, and she beautifully wove it into this piece. So Donna, you can come on, and I'm going to click the slide over in a minute with some great photos of Beth that Donna has shared with us.
Thank you, Ellie, and thank you to the other participants here. The education, and I think that's what we're lacking in. Even as a mother with Beth's story, I was not educated. I had never suffered abuse. My family was not accustomed to that, and I didn't teach my children about abuse. And Beth was a little feisty individual that came into the world thinking that she could change the world and everybody in it. And as a result of that, sometimes you fall victim, and Beth fell victim. She met her abuser in 2005. They dated for about a year. They ended up marrying in the end of December of 2006, and everything seemed to go pretty well until she was pregnant with our Mason, her son. And the abuse still had been there, but it was more of a minimal level until she became pregnant. And I think we see that as a common denominator throughout a lot of domestic violence stories. But anyway, she had the baby. They both were career minded. They were both had goals for what they wanted to accomplish. Beth continued to do hers, and even picking up an extra job that she and her brother did at night, refurbishing airplanes at the Gwinnett County Airport. So she would work her regular job during the day and, do patterns and cut out leather work or carpet or whatever was needed for the job at night, while still trying to take care of a household and her son. But the story gets a little bit more critical as the months go on. Mason was born. It seemed like there were still some edgy situations that came to play. And about 6 months before the major event, Beth started noticing that, I don't remember going to bed in this kind of attire, bed clothes, or she would wake up in a closet, not familiar with how she got there. So, she, excuse me, in the process of that, there was a break-in at her house, and a cop, of course, came to work the break-in, and the husband of the abuser was not there. So she was able to tell him, I'm more afraid of what's in this house than I am what's outside. So he listened to her and, of course, did not give her any kind of shelter information. I did not know that there were women's shelter. That's another uneducated, response or lack of on my part. But he did tell her, he said, domestic violence and divorce never ends well. So I would encourage you, to get away from this individual. Well, for him not sharing, she started on her own path of trying to find ways to leave. And that's a common comment that we've heard during all of this, including in the trial. Why did you just not leave, Beth? And she said, the choices are minimal. You either, stay outside, you go to the victim does not have ample choices. They run away, they tell people, they seek help that make him stop. None of that works. So she set up her own efforts to try to find a rental house, to try to leave and go to another area where he would not know where she was. But this whole time, he's got a tracking device on her phone. Even the day that she called to get an appointment with the attorney, I was in the car with her, and he immediately called and said, "You're not getting a divorce. I'm not ready for it." But long story short, it came down to the fact that she was trying to get the divorce on Friday morning or Friday night before she was supposed to meet with the attorney on Monday. She had not made him leave the residence, but he was not permitted to be in the marital bed. He had a room upstairs. She did that because she was afraid that he would take the baby to unknown places and maybe harm him. So about sometime during the night, he comes in the room through a locked door, assaulted her, and told her if she tried to leave or call anybody that he would kill her, but he would be back to do more harm before the night was over. Well, there are advantages of living close to family and there's disadvantages. The disadvantage was that we were so close to her home in the same community that we're in, and it's pretty much a rural countryside area, that if she tried to leave through an open window or through a locked door, he had the alarm set and he would know when she was trying to leave. So later in the evening, he came in for more abuse, and she had already somewhat, I guess, prepared as much as you can prepare for such a gruesome thought or preparation. She fired the gun and he fell, and she immediately called police. That was let's see, 14 years ago. She has been incarcerated for 14 years. And we immediately felt like, as a parent, you have failed tremendously. You need to either try to hide or you need to try to help. And thank goodness we decided to err on the side of help. And going to the prisons to visit other families, we found that we're not the only ones, that others are living with the same nightmare and some of the same situations. But after she was charged, our investigator started getting hair samples from her, and we learned that there were drugs that had been administered to her. There was evidence of ketamine, hydrocodone that she was prescribed but highly allergic to, and a date rape drug. So we felt like, okay, we're going to trial. This will be a clear thing. But as so many of the others here have described, when the courts don't always see things as they are. They like to see things as maybe the law allows or for whatever reason. But we started trying to be advocates for um, domestic violence victims. Beth, even along with some other great people in this group, had started back in 2015 putting together some legislation that was not nearly as broad range or had as much meat to it as the one that we're dealing with now. It's House Bill 702. And we didn't get any, pushback on what we were asking for. But because of the lack of lobbyists and various pieces of the puzzle that we were missing, the legislation did not pass, of course, and it ended up in a death sentence of its own kind before that legislation was over. But um, our lives have changed. Mason, she got 2 years of bond when this all happened. He was 2 years old, and she was able to be with us until 2005 when the trial started. And she was here one day and gone the next when the jury brought their verdict in of guilty. And of course, Mason was 5 by then, and I remember nights when he'd say, "When is mommy coming home? Will she be home in 3 hours?" That is heartbreaking to try to understand how to explain that to a child when you don't understand either. But he is now 18 and is doing miraculous. We've had to share some of the stories with him about what's happened, but he's taken it with so much maturity and grace, if you can say that with a young man. But finances, of course, have been an issue because we were retired by the time this happened. But anyway, the legislation that's before us, I have so much hope. I have, energy that I didn't think I had that I'm praying for. And these individuals that have come to share, Dr. Ortega has just been a godsend to us when we were at kind of a stalemate with the efforts that we were making at Igniting Hope. But we just hope and pray and will be as active as we health wise and can possibly be to make sure that this is gets in the right areas, of doesn't fall on deaf ears, and that we can hope and see the future for not only our Beth, but so many others that are incarcerated, and the hope of those not having to go to this level of incarceration. I thank you, Ellie, and all the others that have shared the stories here, and I plan to stay involved. Thank you so much.
Thank you so much, Donna. And for Donna and Katrina, I really do hope that you see all the love coming to you from the chat. And I also want to say that it's largely because of Beth's story that we are here today. So thank you, Donna, for sharing Beth's story. So Karima here again, and I realize I am not on camera. I apologize. So here again, just to say thank you so much. We realize we've gone over time. Thank you for so many of you hanging out with us. We want to talk about next steps very briefly. There are lots of ways for you to get involved in the Survivor Justice Initiative. And Colleen said it beautifully earlier today that she could see the seeds of the work that they had been lifting in Oklahoma. And I'm here to say that those seeds that you all planted in Oklahoma are starting to sprout here in Georgia and spread across the country. There is a wave of legislation that's being introduced in other parts of the country that are looking to do the same things we're trying to do here in Georgia. And just reposted some links to the Survivor Justice Initiative website where you can find ways to get involved. You can find the sign up and email list and organizational support letter that you can sign on to. Lots and lots of information about the Survivor Justice Initiative, about what's happening here in Georgia, what's happening across the country. And I'll also plug that we are bringing advocates from around the state to the Capitol for Stand with Survivors Day. We're doing an Advocacy 101 on the 28th and February 5th. We're hosting our in-person kickoff. So if you have not already registered, registration is still open. Please do. We want to welcome you, and we really, really want you to join our efforts in the Survivor Justice Initiative. We need your voices. We need you to educate lawmakers and talk about how you feel about the bill and the stories that you've heard and your own stories. We know New York was one of the first, not the first, but one of the first and the first to actually have a Domestic Violence Survivor Justice Act. So we just appreciate so much everybody's efforts to make sure that we get everybody free. We want to free them all. Ellie gave me a list of things to mention, and I hope I have not forgotten them all. Ellie, if you just want to chime in. Oh, I do want to say again, thank you all for staying a little. We are a little bit over, but we're going to hang out for a few minutes. If you have questions, you'll also be able to, if there's somebody who spoke today on the webinar that you'd like to hear more from, we can put you in touch with them so that you can ask your questions directly, or we can spend some time here asking and answering questions. We tried to answer as many questions in the Q&A as we could, but let's take a few minutes to entertain any questions or comments that you all have.